Hi, I'm Tom O'Toole with Sound Jury Consulting, and welcome to this edition of Soundbite CLEs. I am a jury consultant that is based out of Seattle, Washington, but I work across the country on all different types of cases. And yes, it rains here a lot. I have a PhD in legal communication and psychology from the University of Kansas, also the home of Wilt Chamberlain. I study the American jury and provide strategic advice to attorneys. I've worked in this field for over a decade and have studied hundreds of mock juries, shadow juries, and actual juries. Today I want to talk to you about preparing a witness for deposition. The deposition performance of a key witness is critical to the outcome of any case. Consequently, attorneys should think carefully about how to best prepare the witness for his or her deposition. You don't want your witness to come off like Lil Wayne.
What's your name again?
Hey, well, that's not the question.
What's his name?
Pete Ross.
Huh?
Pete Ross.
Pete Ross.
Yeah.
That's a stupid-ass question.
In this Soundbite CLE, I want to discuss the right and wrong ways to prepare witnesses for deposition. I'll do so by focusing on 3 key tips for preparing your witnesses. First and foremost, practice is critical. As with any skill set, witnesses learn by practicing their testimony. Consequently, the attorney should play the role of opposing counsel and do mock deposition segments for 10 to 15 minutes at a time where he or she asks the witness tough questions. Don't let the witness call time out when they're confronted with a difficult issue. Make them answer so you can see how they get themselves out of difficult places. Follow each 10 to 15 minute segment with both positive and critical feedback for the witness. Recording the segments and using video playback can also help witnesses better appreciate difficulties they're having. Second, don't overwhelm the witness with information and rules. This all but ensures failure. Studies show people remember only 10% of what they are told 3 days after they are told it. So this approach just does not work. I start every deposition preparation session with 4 ground rules. Sometimes I'll even write them on a board. I believe these 4 ground rules cover the vast majority of problems that witnesses run into in depositions. Those ground rules are: take the deposition 1 question at a time. Listen carefully to the question and answer only that question. Don't think strategically and try to answer the question you think is going to follow the question that has actually been asked. Second, think about whether or not you agree with the assumptions and descriptions built into the question. Voice disagreement when it exists. For example, if someone were to say, "Did you buy that ugly shirt at Macy's?" the appropriate answer would be, "Well, I disagree that it's an ugly shirt, but yes, I bought it at Macy's." Third, every answer should come from one of 3 categories: what you personally know and remember, what the records show, or what your common practice was. Anything else is speculation and should be avoided at all times. Consequently, don't be afraid to say, "I don't know" or "I don't remember" when that is the truth. And fourth, don't run away from the facts of the case. Own them. They are what they are, and defensiveness only makes them worse. Most of the problems witnesses run into are accounted for with these 4 ground rules. By keeping it to just 4 core rules and tying the feedback to them throughout the session, it helps the witness avoid feelings of being overwhelmed. These 4 rules make a deposition feel manageable. Of course, we provide other feedback throughout the session as well, but we try to keep these ground rules at the forefront of the session. Finally, it is important for attorneys to have realistic expectations about what a witness can accomplish in his or her deposition. Some witnesses are fantastic and some are terrible.
I don't have a recollection. I don't have a recollection. I don't recall that. I don't recall that.
Some witnesses are not going to be able to push key case themes like others, and the goal may have to be reduced to simply not screwing up. It is important to have realistic expectations. Otherwise, there's a significant risk that you're setting your witness up for failure. For more tips on preparing witnesses, check out the publications section of the Sound Jury Consulting website at www.soundjuryconsulting.com. My name is Tom O'Toole, and thank you for tuning in.